Good evening to everyone. Thank you so much for coming to this very important evening. My name is Doug Silverstein of Keslick and Silverstein, and I'm the chair of CAALA's Education Committee. On behalf of SoCal Defense Lawyers and CAALA, we are very pleased to bring you this program tonight on the dramatic changes that are coming to the Los Angeles Superior Court. Our court is going through an unprecedented crisis due to inadequate funding. Over the last 5 budget cycles, the budget for California state courts has been slashed by $1.1 billion. That 30% reduction is among the highest percentage cuts to any sector of our state government. And because the Los Angeles Superior Court is the largest court, not only in California, but in the nation, maybe even the world, it has received the steepest percentage of this $1.1 billion in cuts. This is having a direct impact on access to justice and the court's ability to do its job. This truly is an issue which the court, the plaintiff bar, and the defense bar all have an equal interest in. And civil courts are feeling the cut more than anyone else because civil litigants don't have the same constitutional safeguards that criminal defendants have. While we continue to lobby the legislature for additional court funding, we're very fortunate to have leaders in the Los Angeles Superior Court like Assistant Presiding Judge Carolyn Kuhl, who's here tonight, and the Supervising Judge of Civil, Dan Buckley, seated to my left, that thankfully understand the importance of safeguarding our civil courts in these times of increasingly scarce resources. This issue is so important that there are over 35 judges here tonight, and I'd like to ask them to stand and be recognized. I'd also like to recognize, standing over there, our State Bar President, Pat Kelly. And as you can see by this large room, between this room and everybody milling about outside, there are over 370 attendees here tonight. That's how important this issue is to our community. Tonight, Judge Buckley is going to give us up-to-the-minute details about the changes that are coming and how our Superior Court leaders are going to deal with these drastic budget cutbacks and deal with the reality of the new normal of less funding than is needed to actually do the job. Judge Buckley is actually a double leprechaun. He earned both his undergraduate and his law degree from Notre Dame. And in high school, a little known fact that you may not know, he won the Coaches Award consistently, which is a nice way of saying he wasn't very athletic, but he hustled. He also won the 8th grade math contest and used to defend toxic tort cases. I'm sure those experiences will be very helpful in dealing with the court's budget crisis. Please welcome Judge Buckley. Now, seated all the way on the far end of the table is my co-moderator for this evening, Jeannie Harrison. She's very well known for her incredible civil rights and employment law verdicts, but you may not know that she actually believes that height should be rounded up to the next inch and weight should be rounded down to the next 5-pound increment. She has also tasted armadillo meat and is famous for her Texas hey-alls. Please welcome Jeannie Harrison. Now, in addition to leading the roundtable with me tonight, Jeannie will provide the latest information on ADR options because, as you will hear from Judge Buckley, the Los Angeles Superior Court will no longer have any ADR options. So everything is going to come from outside the court. And we'd like to thank SMMCA for some information that they provided, and Jeannie's going to be talking about that. Now, after we take a very short break, we've got an all-star team of plaintiff and defense attorneys who will be joined by Judge Buckley to give you their feedback on what all these changes mean for the litigants. Jeannie and I have a lot of questions for them, but you in the audience can also ask questions. This is your opportunity. We're going to have an audience mic, and David Hoffman's going to be running around with that, but you can also email Jeannie or me with any questions, and we can ask them for you. My email address is doug@caala.org. That's DOUG@CAALA.org. And Jeannie's is GENIE@caala.org. And so what I'm going to ask is this half of the room, email me, and that half of the room, email Jeannie. Now, for the roundtable, we're very pleased to have Phil Baker of Baker, Keener, and Nara, seated second to my left. Aside from being a great guy, Phil prefers Van Halen with Sammy Hagar. I think he's in the minority on that. He's been to 5 Lyle Lovett concerts, and maybe we'll get lucky and he'll sing us a little Cowboy Man. And he used to be the Los Angeles Transportation Commissioner. I think most of us in this room would like to have a word with Phil after this seminar about our commutes. Please welcome Phil Baker. We are also very fortunate to have with us Denise Taylor of Taylor Blessey. She's arbitrated or tried over 150 cases. 150. She's the president of SoCal Defense Council, and she even met her husband on an Aboda cruise in Italy. She's a huge basketball fan and has Lakers season tickets. And given the year the Lakers are having, I bet she'd give you some if you ask her. Please welcome Denise Taylor. Seated to Denise's left is Steve Glickman. He's a fantastic trial attorney and an even better guy who's a past president of Aboda and was one of the youngest members ever admitted 20 years ago. He and his father are also the first father-son Aboda members in Los Angeles. Steve is the only guy I know that tried an accident case against a trucking company where the jury found the trucking company 100% liable. Then the trucking company was so impressed with Steve, it hired him to represent them in its legal malpractice case against the attorneys that Steve beat at trial. And because a malpractice case has the case within the case, Steve had to try the case again. It was the exact same case, but this time representing the trucking company, the jury found that the trucking company was 0% liable. Please welcome Steve Glickman. Last and certainly not least is Gretchen Nelson of Kreindler & Kreindler. Gretchen is a true leader of the bar, having served as the LACBA president and is now on the State Board Bar of Governors. She has chaired LACBA's Judicial Evaluation Election Committee and was just recognized 3 weeks ago with the Jim Roby Professionalism Award for her incredible civility. In college, she actually majored in music. I just found that out. You might have noticed I did a little digging before tonight's seminar to find out some information that may not be widely known. And because she majored in music, if you give her another drink or two, she'll be singing in the bar after tonight's program. Now, she doesn't just have the usual pets like cats and dogs. She has donkeys, horses, and even cattle. Right on, cowgirl. Please welcome Gretchen Nelson. All right, it looks like that gave an opportunity for everybody to get in here. So at this point, I'd like to turn the podium over to Judge Buckley.
Thank you so much, Doug. It is true that I am not an athlete or athletic at all. The way my coach in high school described me was that I was short, but I was slow as well. So it was very distressing. Thank you so much for being here. We on the bench know full well that one of the many advantages that we have as being bench officers on the Los Angeles Superior Court, in addition to having great colleagues, is really having a fabulous bar in our county and working with us. And I think tonight is just one of many examples. And I'll give a couple others as I continue to talk about the last several months and the future. So we know that you're interested in this. We know you don't want to do this, and it should not be a secret, but guess what? We do not want to do this. But we're working with you, and we're confident that we will continue to be the best court in the world, and in turn, we'll be doing that with the best bar in the world. So thank you for being here and expressing your interest. May I ask, just by a show of hands before I start, how many of you don't really know much? By a show of, just raise your hand. Either you've not been to a prior seminar or something. So a fair number. Okay. The seminar has its name, but I want to refer to this as a presentation on further budget cuts. And that's because this is not the first time that we in LA are experiencing budget cuts, because it's not the first time we in the judiciary are experiencing budget cuts in the state. And so that will be part of the analysis and also the fact of where it's really going to hurt the courtroom as well. But before I start, Doug did me a favor to do what I was planning to do, is have all the judges stand, and I appreciate that. Let me just take one more moment to acknowledge Judge Kuhl. Judge Carolyn Kuhl is our assistant presiding judge and was very instrumental in the good ideas that are in this plan. I'll take the bad ideas. Judge Kuhl can get credit truly for the good ideas. I have said this before, that she has an unbelievable ability to think outside the box, but also be just scary smart. And so we are so lucky for her to be our leader on the bench, and I think we have a dear friend in the civil arena with that. So Judge Kuhl, thanks for being here tonight. What we did over the last couple months is to create teams that took on the certain types of civil cases as well as the other types of cases. Judge Ann Jones, I don't believe, is here, but Judge Jones has really taken on the overall leadership of the implementation on this. And so the next time you see Judge Jones, thank her. She has given up her courtroom assignment, is literally in a small room, but is the leader on the day-to-day decisions and is doing an unbelievable job. So she's not here to clap, but thank her, shake her hand, and express your appreciation to her. We had leaders of certain teams, and a couple are here. Judge Amy Hogue, who is one of our IC judges in Mosque, led the small claims team and did a fabulous job on that and will continue to be instrumental in the small claim court. So Judge Hogue, thank you so much. Judge Kevin Brazil took the lead on the limited court, and we'll talk about how that's being dramatically changed. Again, not only coming up with great ideas, but just superb leadership on a team that involves bench officers as well as staff. So Judge Brazil, thank you so much. And then finally, one other person I want to acknowledge, Judge Mary Thornton House. I don't believe she's here. She sits in Pasadena. Judge House was actually an advocate for some of these ideas in the past as to handling collection and UD cases. As a result, she led the teams on both collections and UD and is a fabulous leader, also someone that thinks so well outside the box. So again, if you see Judge House, thank her for her leadership and involvement in this. So I mentioned that this is further budget cuts. So I just want to mention quickly that we've experienced in LA $105 million in cuts before we're experiencing what we're here for tonight. What we have done is, in essence, spare the courtroom. We have suffered, both with the judges and our staff, in severe cuts in service, if you will, internally. And so never forget that this is not our first time in dealing with cuts, and it makes the reason why we cannot avoid doing many of the things that we're going to talk about tonight. And one thing you need to keep in mind is that numbers are thrown out and they're statewide, and then numbers are thrown out and they're specifically to our court. So again, that is an amazing number, and that's just the cut to our court before now. And we're, I don't have the exact number at my fingertips, I apologize, but we're basically well over 15% less staff than we had several years ago. What we're facing now is something between $56 million and $85 million. And I've said this before, and if you've heard it, I apologize. I always feel like I'm in an Austin Powers movie. When, you know, that scene when they say $1 million, and there's this emphasis. It's so much money, I do feel like I'm back from the 60s, if you saw the movie Austin Powers. And it's a number that just is hard to put your hands around. It really is staggering. Come Tuesday, we're hoping that some decisions will be made by the Judicial Council and some other places where we might be able to deal with that $30 million gap. And tonight's not the night to explain what that is and why. But we're hoping that good minds will make some good decisions and allow us and other courts to have certain types of money so that what we're looking at is a 56, not an $85 million cut. Because candidly, if we have to go above 56 million, we have to go back to the table and think of further ways to have cuts in our court. So for tonight's purposes, the good news is that the cuts and the changes that we're talking about, we believe comes very close, if not to, $56 million. And when we started this process, it was a chicken and egg process where we weren't sure if we did this, how many people really would be involved, and if we did that, what kind of money that would be. But led by Judge Jones, we are now to a point that we believe we're very close, if not at, the $56 million. So again, if you want to see the glass half full, by these cuts, we're able to go forward and deal with it. But we are also looking at, in essence, permanent or indefinite cuts on the process. So you want to know basically my role. You might think it's just my title as the supervising judge of civil. It is not. If you haven't seen the movie The Closer, I would highly recommend it. Not that, I'm sorry, The Cooler. If you've not seen the movie The Cooler, I am not endorsing anything. I'm not asking anyone to pay money toward anything in any way whatsoever. But if you have not seen The Cooler is, and I am the William Macy character. When someone is really winning a lot of money at the craps table or something else in Vegas, they send the cooler to the table. And then he just completely knocks all the momentum going on that table, and then someone stops making money and Vegas prevails. And I feel like they just send me off to be the cooler in all these different meetings, that you're all smiling when you come here, and after you hear it from Buckley, it's just a bummer. So that is my role. So back to the plan. This is the legal language that it's always put at the end of a contract or at the end of the movie or whatever it might be. The implementation plan is still subject to revisions and modifications based on various factors. And very directly what that is that the criminal and traffic plan needs further discussions with our justice partners and really have them understand. And that also is very significant, by the way. We have police agencies, for example, that literally can walk across a parking lot and do their filing, and now will have to get on the freeway and drive 5, 10, 15 miles to the next court. So we need to sit down with them. But in general, for what we're talking about tonight, and definitely what I will tell you about, we believe is pretty certain in the civil plan. There will be reductions in all court operations, and I do need to take a few minutes just to emphasize to you that all of us on the bench, all of us that are handling any type of case in our court is being impacted. Because you hear comments sometimes as, why is civil being hit so much, or why is only civil being hit? And I can assure you this is across the board. As Doug talked about, because we don't have certain constitutional issues, there are not the same public safety issues in civil. We are taking more of a hit than some of the other disciplines, but I can assure you that they are being hit. And also with that, we are trying to meet our constitutional requirements as well as our statutory obligations. We're trying to deal with all litigation types. We need to address the most effective use of our bench officers. We want a fair and even distribution of all the resources. And also, we need to keep an eye on technology and have some investment, which will come up at different points. We are closing 10 courthouses in our system. And the names of those, or the locations of those courts are provided. I'm not going to read them to you. But obviously, that can be extremely significant. And what that ties to, again, is to not only the savings that we achieve by those people working in those buildings no longer being in that position. Now, again, with union issues and so forth, it's not, if you worked in this courthouse, that does not mean you will no longer be with us, but that job will not be replaced, and you'll have to move on to someone else if, in fact, you stay with the court. So again, some very significant changes with courthouses. And that ties into the impact on access, how close you are, and we'll get to some numbers on that as well. The criminal courts and traffic, I did mention that they are experiencing some ongoing discussions with our justice partners, but what they are doing is having right now a net reduction of 12 courtrooms. Those cases are being distributed throughout the criminal courts. We're going to reconfigure over where the Twin Towers are. If you don't know, there's some courtrooms there. And in the midst of all this, why we are being hit with cuts, we're getting more work. And if you're not aware, that parole violation hearings, which was never a function of the court and a judge, is now, by recent law, something that we now have to deal with. So as we take on thousands of parole violation hearings, we're moving those over out of that courthouse or those courtrooms and dealing with that. We're having a significant consolidation of traffic cases, which one, again, makes you travel farther to get to the traffic court. We're going to have longer lines in those courthouses that are going to be dealing with traffic, and the process will go slower. So we'll have to keep that in mind as well. Juvenile, we're going to close the Kenyon Juvenile Center, which entails closing 2 courtrooms in delinquency. And if you don't know, there's delinquency and dependency. And we are terminating our referees. Again, the human impact, as well as the impact on money issues, is dramatic. I don't know if you've ever dealt with dependency and delinquency courts, but our referees are such talented and devoted people to the cause of children's justice, is that it is just a tragic loss for us in talent, as well as just dear people that we're losing. But they are being let go. They are aware they're going to be let go sometime between now and June. Also, we're going to close the dedicated adoption court. Those cases will still be handled over in Edelman, but they will not have the dedicated court and have the ability to deal with that. Family law, 10,000 civil harassment hearings are going to be added to the family law courts, which is a dramatic increase in their workload. And again, hopefully you've not had to deal with a civil harassment case, but it can be extremely emotional, very volatile at times, and can be very time consuming. So with that, we're looking at a conservative increase of 15% increase for the bench officers that are doing that. Family law dramatically has an impact. Probate, we are taking all of the probate cases, whether they're in Pomona, Lancaster, Long Beach, etc., and bringing them all downtown. And there's an efficiency cost savings there that is dramatic, but again, some of the access is staggering as to the impact. And again, I don't know if you've dealt with conservatorships of elderly people, people with certain disabilities, limited conservatorships, people that have severe disabilities, as well as guardianships where children's lives are at hand. They will need to get on a bus, get on a train, and come all the way downtown for their day in court, which again is dramatic. We are going to try and have some bench officers at different times go to these other courthouses, but at least the filings and the trials will be downtown. And it's dramatic impact, unfortunately, and it just tears our heart out to have this kind of change in servicing our people in our county. But it's something that we have to be done. And I think that's as good a glimpse into how we here are not the only ones being impacted. And it's impacting obviously the bench officers, but those people that come to us to be served. And again, can't say anything better than it tears our heart out that we have to deal with this in this way. So I know you're here for civil. Hopefully you now have an insight into the fact that there's a dramatic change across the board of our court. The big picture in civil is that we're going to have a bench officer dedicated to one case type. And again, if you're doing general civil, you probably don't see this as much. But out in the districts especially, we'll have a judge do 20% small claims, 30% traffic, 20% UDs, and then 30% of some other case type. And it provided great service. We'll talk in a moment. We had roughly 26 courts throughout the county providing these type of services. And people would go 2, 3 miles, maybe walk down the street to get that small claims matter resolved. And what we're going to do is bring them all into one location, far fewer locations, and have that judge deal with one case type that creates a lot of efficiencies both in the courtroom and behind the courtroom. We are going to achieve the savings through the hubs. You'll hear that word. That's when we're bringing these cases together. We are going to use what we call differential case management. You might think of a master calendar approach. We're not going to use that word for various reasons, but we'll give you specific examples as to how that is. But on collection cases, PI cases, and then limited cases that are not collection cases. And then we're going to maintain the IC courts. One of many examples where Judge Kuhl took on the leadership. You want us to have IC courts. We want to have IC courts. I am old enough, gray hair enough, back in the 80s to have a beeper. It used to be my big day. I was with Breidenbach, and Fran Breidenbach would give me this big thrill to go into court, and I would get the beeper in Department 1 and bring it back to Fran. And that was my day in court when I was a young lawyer. But it wasn't very efficient, and we were on the eve of a 5-year case every day. And what happened is that the bench took over and became a participant in getting this case resolved. And for you to have a trial within a year, when that happened a couple years ago, it was because of the IC system. You want that to continue, and it will continue, but we got to get through this and handle other cases in a different way while we maintain the IC system. And we're going to have to reduce the number of courtrooms, which again we'll talk about, and we're going to reduce staff, which is going to have a dramatic impact on you. Small claims. We're now going to talk about each of the individual types of cases. Lancaster basically for the UD and small claims will stay the same, but we're going to have all of the small claim cases in 5 different courthouses. Again, think about that. We're going from 26 down to 5 locations. People are going to have to drive up to 25 miles to have their small claims case resolved. We're going to have over 61,000 cases distributed among these 5 courts. And they're in Mosque, Alhambra, Downey, Van Nuys, and Inglewood. This shows you, I'll just quickly go through it, but it shows you how we're having cases come across district lines now to have their day in court. This gives you a little picture of the geographical spread as much as we tried throughout the county. Unlawful detainers. Again, we're dealing with somewhat access and distance issues. We again had 26 courts that had UD cases. Go to the last line. People are going to drive up to 32 miles. People that are dealing with being kicked out of their home, probably don't have a car in the driveway, are going to have to get to court for these type of cases. We're looking at 67,000 of these cases among these 4 courts, and they're going to be in Mosque, Pasadena, Long Beach, and Santa Monica. And if I take a moment, what we did is because Mosque was a court that had one judge handling these cases, we're trying to mirror what we have done successively in Mosque. So with Commissioner Bill Dotson doing such a great job in UD cases, Commissioner Robert Harrison, as well as Commissioner Matt St. George doing the small claims in Mosque, we're taking the same number of cases that they have handled over the last several years and have that be the number of cases handled in these different hubs. So that's sort of the approach that we're doing on that. Again, this is how the cases are coming from different districts. This gives you a picture of the geographical spread. The limited civil picture, well, we recognize, and again, this was led by Judge House and her wisdom, we have 83,000 filings a year in cases that are under $25,000 in value and are a collection case. Credit card companies, for example, are an example of that. So right now, for these type of cases, we recognize not only they have a certain approach and people don't necessarily come to court that often, but approximately 50% of these cases result in a default. So we're not looking at trials and so forth. So that's why we pull the collection cases out of the limited courts, put them in 2 locations. So 2 judges in Norwalk, 2 judges in Chatsworth will handle these cases. People will have to drive up to 67 miles to have access to their day in court. If there's a trial, we don't expect too many. They will go to the stand-alone trial courts, which I'll discuss in a moment. These assignments, that's actually, what that then leaves us with is that there are about 20,000 cases a year, filings a year, that are not collection cases. And they will be held or handled in the mosque courthouse in 1 courtroom. So Department 77, if you do limited work, will stay open and continue. 2 bench officers, Judge Stephanie Bowick and Judge Michael Raffel, will handle these cases. There will be a significant increase in workload because when you take the collection cases out and replace them with non-collection cases, you have a much higher percentage of cases with law in motion and discovery disputes. So even though they're roughly handling the same number of cases that Department 77 has been handling over the last several years, they face a significant increase of day-to-day work on that. And all cases that are not a collection case, under $25,000, will be heard in the limited court downtown. So if your accident that's under $25,000 happens in Long Beach, Santa Monica, even Lancaster, it will be filed and handled in downtown Los Angeles. The trials will go to our standalone trial court. We'll come again to that in a moment. But we cannot guarantee that they will go to where the accident happened. So as a result of that, what we're facing is you could have the accident in Long Beach, it's handled in downtown Los Angeles up to trial, and then it goes to Pomona for the trial. It is an amazing situation. We recognize that, but it is, again, the only way we can handle the processing and the existence of the trial courts. That shows you the distribution of the, in geography terms, the 2 red dots are the collection hubs. The yellow dot is the 1 remaining limited court for non-collection cases. On the general jurisdiction, probably after all this talking, I've gotten to why you came here maybe. But again, to stop for a moment, we serve a lot of different people asking for a lot of different types of relief. And when we get to this point, or I should say we can only get to this point in discussion after dealing with these other problems. Again, I've talked about keeping the IC courts. What we're going to do here, again, is we're going to identify a case type that we feel doesn't come to the courthouse as often as other types of cases. We're going to pull out the personal injury cases. And very directly, I've heard comments, are you picking on PI lawyers? Absolutely not. We try to do a study. And if you've heard me discuss this, you've probably heard this line. We are on the DOS system in Los Angeles Superior Court. Now, the younger lawyers in this room don't even know what DOS is. For your purpose, I've just mentioned a dinosaur in the computer world. So why I mention it right now is that we decided to do a study. Most of you in your firm could push a button and get the results of this study fairly quickly. What we have to do is have someone, a dear person that I bonded with very much, spend days to do a study on PI cases. But what that study revealed was that 82% of PI cases have 4 or less appearances in a court. And that would include a CMC, the trial date if it goes that far, etc. So it provided proof of what we suspected, and I think what you probably thought too, is that those cases just don't visit us as much as anyone else. And sort of the big picture of what we're talking about is we have to reduce the number of jobs our staffs do because we're reducing our staffs. And bottom line, we have to have less minute orders. So we're going to pick the cases that don't create minute orders, as much at least, put them in the same courtroom, and deal with them in the same approach. We have 18,000 annual filings on PI cases throughout the county. They are all coming downtown. And we heard by 3 courtrooms and 5 bench officers. The travel will be 67 miles, or a maximum 67 miles. And we'll go into some detail on the PI cases, but they will then be sent out to the standalone trial courts, and we're having a reduction of the staff in the courtrooms across the board in general civil. Doug talked about it. We are terminating our ADR department. Very directly, we see a savings of about $1.7 million. But we recognize fully that the result on your cases, which means our cases, will be dramatic. And we need help on this. And we'll talk about that in different ways. But we're going to terminate the entire program, whether it is the pro bono program, whether it is the pay where you spend money for 3 hours, the voluntary settlement program where you brought in a plaintiff's lawyer and a defense lawyer to sit on a PI case, all of that's stopping. And some of you have been so great in volunteering and quickly saying, Judge, we'll do that for you. We'll handle that settlement conference for you. And we thank you for that. But that's not what we need, and that's not why we're doing this. We need staff. We have a vibrant department that has become, I strongly submit, the best ADR department of any court in the world. But it takes people to do that. Schedule it. Make sure that it's handled right, that the dates are actually complied with, that the information gets back to the courtroom. If there's a complaint, that the complaint letter is handled properly, et cetera, et cetera, et cetera. And so we are trying to seek alternative programs dealing with, I don't even want to mention, there's no intent of any pressure, but we're going to try and see if others can step up and provide the staffing of the program that then will allow the volunteers to be able to coordinate with the court. The PI courts. So I'm going to elaborate a little bit on that. These are the 5 judges that will be serving us, and they are fabulous. I am so proud that our court can bring the talent of these 5 judges to you, and I think you're going to be thrilled with their talent and their work ethic. Judge Rita Miller, I think most of you know, she's sitting in Mosque in an IC court, as is Steve Clyfield. Judge Clyfield also, great background in civil litigation. Judge Rafael Angeko was with the county council, has handled many different types of courts, currently running our limited courts and does a fabulous job there. Unless you practice with them as lawyers, because they both did civil work, you may not know yet from the judicial perspective, Judge Teresa Baudet, but years of great actual courtroom tried cases for some really good firms, Mayor Brown being the last of the 2 or 3 that she worked for, and Judge Elia Weinbach, again, fabulous trial attorney, was in the courtroom as a lawyer, has been doing family law, so I think you're going to be very pleased with them working with you. I do want to just take one moment. We sought out, and the bar sought us out, to try and sit down and work through the procedures and the policies and so forth of this PI court. Dan Crowley, who is chair of the litigation section of the LA County Bar, took the lead. But if you were working with us on that, would you stand just for one moment and be recognized for your good work on that? Okay. So someone mentioned, and I won't even use the exact word that was mentioned, that maybe what that group did most of the time was just complain to me. But that's not true. They came forth with some great ideas. They listened to our ideas, showed what might work, what might not work. And we're not going to promise we're going to do everything that was raised during those meetings, but it was invaluable. And as our 5 bench officers get together now and finalize things, it's because of the work provided by you all. The definition of a PI case will be in the local rules. Basically, if you go to the cover sheet, the civil case cover sheet, and go down the column where there is auto cases and other types of cases, product liability, medical malpractice, all of those will be in the definition of a PI case. I decided not to put up because it would just fill up the screen too much. But go to that cover sheet and that will give you direction as to what is defined. Except, the exceptions will be asbestos cases and toxic tort cases. Are med mal cases included? Yes, they are. One thought among many is that, candidly, when med mal lawyers are working together, many times they cooperate. We don't get as many discovery motions. Obviously, if it's a more complicated case, we'll recognize it does not belong in the PI court. The thought is that plaintiff's attorney is going to file the complaint, and at that time, we will give that plaintiff's attorney the order. The order will give a trial date, probably 18 months or so out, conditioned on the service of the defendant or defendants being made within 6 months. So what will happen then is that you have an FSC order, you have an FSC date, you have a trial date, and you have a 3-year date plus 1 day. And again, within the philosophy is, on these cases, you don't want to see us, we don't want to see you. And I say that with all due respect. Even we judges can say, with all due respect. But the thought is that if we're going forward with the same statistical information, 82% of these cases really don't come to the courthouse. So we're going to give you the dates that make you have to come back for at least 1 or 2 of those events. If somehow this case falls through the cracks, whatever, 3 years later, we will now deal with a motion to dismiss based on the failure to prosecute. What is not here is that our thought, we haven't finalized this yet with our judges, is we probably will have you be able to stipulate to an order to continue the trial. Not necessarily in the IC court, but we have spent so much time and good time with IC courts to bring you in every time you didn't meet a deadline to serve a defendant. We have sat with you time in and time out to make sure that certain events happen in a certain period of time. And there's no other way than a very direct way. If you don't really want this case to go to trial, we'll see you at the 3-year date. If you don't want this case to be tried until we get closer to the 5-year date, we'll see you then. I need to be direct with you on this type of stuff. So that is the approach. Now, we're told by many PI attorneys that that's what you want, and I think that works out well. But you'll have all the information you need to show up for the FSC. We hope that we will not have to have case management conference. Again, led by Judge Kuhl, we're in the process to get a rule change as to specialized courts such as the PI court. We hope to have a final answer next week, but the thought or the goal would be that, again, you would not have to have a CMC, a case management conference. And so in turn, what you would have is FSC being our time that we first really would like to see you if you don't settle the case. Again, CMCs are required by the rules. We're trying to deal with that as we speak. You may think that this case is too complicated. That's the word we're using for an IC court. This is that 20 or 17% situation where you're going to need more than 4. And that 4 is not the magic number, but it's a case that you need to come in for law in motion, discovery disputes, and so forth. So we'll have a process where you'll tell the court that it's, quote, complicated, close quote. I'll show you in a moment some of the criteria that we're thinking of. Probably not have a hearing. We probably do not want to see you on an ex parte application. And even if you stipulate, we may not agree. We may not necessarily transfer you to the IC court. But we recognize that there are cases that do require the TLC, but what the IC courts provide. And we will give you that opportunity to transfer to an IC court. This is the language, but it deals with everything you can think of: length of trial, number of experts, et cetera, et cetera. The definition was even longer, so that's why I didn't put that up. We'll provide this to you later on. Jury fees, if that's a question we get a lot, so I thought I'd throw that out. If you don't know, CCP 631B and C talks about 365 days after the filing of the complaint. We are working on the process of discovery motions. We may well require require informal conferences before you bring us a discovery dispute. We're working on that. We may approach the hearings in a different way, but we're working on that. We're hoping to get with our DOS system to have an online motion reservation. Riverside, as you may know, has that. So we may not have it up and running when some of the dates that you'll see in a moment occur, but nonetheless, we are going to have that for you in all the different courts, but including the PI court. The PI judge will handle the final status conference. We're looking at 8 court days before the trial date. The bottom line is that we need you to be ready. And I'll talk in a moment at the very end of what can you really do. Be ready for trial. If the rules tell you to do a binder with joint exhibit lists, do it. I'm using my judge voice as Judge House does. But what we need you to be ready. And if you want to get out for trial, you want to avoid any ramifications, be ready on that FSC date, because we will expect strict compliance. We're going to try and have an ADR system between the FSC and the trial date, but we'll look at some numbers that are staggering in a moment, but we're looking at maybe a crash program on the PI cases in May or June, which is about the time we think we'll be fully up and running with all the cases. We'll probably have periodic crash programs. But what we're looking at is some type of a system. How our judges are involved remains to be seen, but we probably will ask for daily volunteers from you. Have 3, 4 of you with 1 or 2 of us in the cases that are ready for trial in the next couple days. We'll try and settle them that way. So that's still in the staging plan. You will then be assigned to Department 1. I'm not sure if I personally will be there. I guess if I talk as much as I am tonight, you don't want to see me. But that is going to be our only master calendar department. We're not calling the PI court a master calendar department. We're not calling the limited court a master calendar. You know the law. Whatever the law is, it's to the 170.6. When you're in a master calendar department, i.e. exercise your peremptory before you leave that room, that will be in the master department 1. We're looking at 31 trial courts. Again, I'll give a couple more details on that. 10 of them mosque, 21 of them throughout the county. And this is some tough news. The availability will dictate where you go for trial. We recognize, I did 22 years with the Breidenbach firm as a defense lawyer. I know where the jury pool is, where the court is for that trial has impact on your analysis of the case. But we're just not able to do it. One, we have districts that are not going to have trial courts. We're going to have districts that are going to be occupied by the UD courts, filling them up with trials. So we cannot right now tell you that you'll go back to where you should have been without the PI court. And so it may be in downtown. And again, using the example, you could have an accident in Pasadena, heard in the PI courts downtown, and the trial could be in Torrance. I need to talk just a minute about transferring cases. If you go into my conference room, I've got 2 walls filled with diagrams that look like this. Every courthouse is sending out different kinds of cases to different places. So between April 2 and May 20th, we have cases going all over the place. With that, we're taking 20,000 cases from the districts and mosque into the 3 courthouses. So in addition to a 16,000 cases filing per year, or the number that was there earlier, we're bringing in 20,000 existing cases. So we know that we have some challenges ahead of us, but the alternatives are far, far worse. What we hope is by March 18th, the mosque IC cases that are PI cases will be in the 3 PI courts and being handled that way. And then you'll see in a moment on a calendar, March 18th is the date that all new filings will occur. So if you have a limited case that's not a collection case, as of March 18th, you'll file it downtown. If you have a PI case, no matter where it occurred, even if you think it's complicated, It will be filed as of March 18th downtown. This shows you the transfer dates of with the schedule from the districts of your PI cases. I'll give you a moment to look at it. Chatsworth, Norwalk, April 2. Pasadena, April 8. Compton, Long Beach, April 15th. Antelope Valley, Burbank, Pomona, April 22. Glendale, April 29. Santa Monica, May 6. So as of that date, your PI case that was in one of these places will then be as of that date be handled, the existing case, in MOSC, in the 3 PI courts. The Van Nuys date is not there. I'll get it to you when we take a break. Pardon? Boy, there was some problem on someone's transcription. Okay, I'll get Torrance, Van Nuys. Okay. Trial courts, again, they're going to handle PI cases, UD cases, and limited cases, as well as collection cases. If you go back to the UD hubs, probably those UD hubs will fill up the trial courts. So Long Beach, you probably will not get very many PI cases being sent to Long Beach, Pasadena, and Santa Monica. But Santa Monica has 5 trial courts on that. No court reporters. We are not going to have any 3/5 court reporters. There will be no court reporters provided by the court for any civil case, except for writs, and definitely not for trials. The good news is that you can go full day, 8:30 till 4:30, so our trials should take less days. The assignments for these trial courts are not decided, both for downtown and in the districts. We're very close to it, but for various reasons, we're not able to announce those assignments. These are the number of trial courts, adding up to the 31. 10 in MOSC, 1 in Pomona, 2 in Pasadena, which does have a UD hub, 1 in Chatsworth, 7 in Van Nuys, which does not have a UD hub, so may get a fair number of overflow from MOSC. Long Beach has 2, but they have a UD hub. Torrance, 3. Santa Monica has 5 trial courts, does have a UD hub, but clearly there'll be some trial courts not day-to-day dealing with UD cases. The IC courts, we're going from 45 to 34. Think about how we're taking 25% in MOSC of PI cases out. As a quick aside, we're taking up to 80% of PI cases out of the districts. But nonetheless, you know that Buckley is not going to be there. No cheering right now. Judge C, Ramona C, is now in Torrance. You've seen that Judge Miller and Judge Clydefield will be in the PI courts. So 41 minus 34, there are 7 other judges that are currently in an IC court that will be in some other court. We're close to the decisions, but we're not able to announce who those 7 are or where they're going. There are no court reporters in the IC courts, no half days of a court reporter for law in motion. If you want a law in motion heard with a court reporter, you must bring the court reporter. Always asked about e-filing, and I agree with you. We would love to have e-filing. Remember, we're in DOS, so we have an infrastructure that's a little difficult to put the e-filing on, and we're talking about lack of money, but our leadership is doing a great job in exploring how we can get e-filing, but we're probably years away. We are going to restrict the time that you can call the courtroom. Again, it hurts us to reduce the service that we're going to provide. You're going to create an incentive to use the online motion reservation. We're going to push more with our judges to have as much information on the websites for the typical questions, but we may have only an hour to an hour and a half in the day where the phones will be answered, and you will not be able to leave messages. All of that results in less hearings that we will be able to provide you because of different things. So what does it mean? And this could be another discussion, and I apologize to the panelists because I know I've gone longer than what was suggested. But I made a point to contact just 2 or 3 of my colleagues in MOSC And I just asked, did you have any hearings today that you struggled as to why it was filed? And unfortunately, each one of the three had at least one, and in fact, one had several examples. And the way I try to explain it in the courtroom before I went to Department 1 is, right now, we have only so many slots that we can give you for your dispute, whether it's a discovery motion, whether it's a summary judgment motion, or it might be an anti-SLAPP motion. And that number is going to be reduced. We have to. I haven't gone into, for example, that we're going to reduce the court staff. There's only going to be a JA in the trial courts, and in the IC courts, we're going to have less court assistant time put toward each courtroom. So we're going to have to reduce that number. And we can spend a long time on very specific ideas, but we need you to bring us the disputes, which is the reason why we went to law school. And if you want to bring us that discovery dispute, because he won't talk to me, if you bring that discovery dispute that requires a judge to spend hours because neither one met and confer, if you're going to create battles on that type of stuff, we're going to have to give you a slot. But because of that, your summary judgment hearing, which is why we went to law school, will not be 8 weeks away. And I know in some of my our courtrooms, it's even longer than 8 or 12 weeks. It's going to be months away. We have to work together. And I know we're going to spend time with your questions. We're going to address that. But it has happened. Judge McCoy, yet another great leader of our court, was accused, it's just terrible, was accused of being Chicken Little. And unfortunately, he was right on, as all of our leaders have been. And now it's in the courtroom. And if you can change the amount of money that we are not getting, that's great. But we're not expecting that to happen. So we're going to have to work together closely and let us do the job that you really want a judge to do, and you do a job that you should do as a lawyer. And if there's a demur to 3 or 5 or 13 causes of action that simply sort of cleans it up, you know what? Don't bring that to us. Again, that's discovery motion. Let us work together to accept reality that it's a different world, and we are devastated. But we also believe the fine judges on our court will work with you, the fine lawyers in our court, to get through this. And hopefully one day we can increase the IC courts. Together we can sort of get back. We're going to get through it, and we're going to get through it together, but it's just going to be tough. What I was going to show you is sort of a bottom line that we are going to slow down, and we have to accept that. Our bench officers have to accept it, and you're going to have to accept it. And we don't want it to happen, but work with us. So on that lovely note, thank you so much.
Thank you very much, Judge Buckley. For those that have tried or litigated cases in San Francisco Superior Court, they know the massive problems that they have there. And by comparison with the proactive leadership that we have from Judge Kuhl and Judge Buckley and their predecessors, we're really in the best position here in Los Angeles County that we can be to deal with this significant budget shortfall. As Judge Buckley indicated, there is not going to be any further ADR program in the Los Angeles Superior Court, but there are going to be options. And to tell us a little bit about that, I'd like to call up Gene Morrison.
All right. Here, I want to just give you a little bit of information. Things are obviously at their infant stage here. Actually zygote in terms of other options for ADR. Can we see by a show of hands who has had a case that is resolved through the court's ADR program, regardless of whether it's mosque or any district? Anything, okay. And regardless of whether it's mediation or voluntary settlement conference, the crash program, so there are quite a few people. The reality here is that, the program, as the judge said, costs about $2.5 million to run. There are organizations out there that I'm going to tell you about that are trying to figure out, is there a way that we can fill the gap, especially on those cases that are basically $50,000 and less in terms of a demand or of a potential value. Now, there are a lot of cases that go through the system. Basically, 9,900, almost 10,000 general jurisdiction unlimited cases go through this system each year, each fiscal year. And about 39% of those resolve through the ADR mediation program. That's just the mediation program. So that's a big number, a large number of cases that are getting resolved just from the initial mediation program. I believe that the ADR program is going to have to be closed down and done by June. Is that correct? Okay, so June. My understanding is the cases are going to stop being referred to the ADR program, and Judge Buckley, you can correct me on this, but around March. Is that right?
Yes, it depends on the type of ADR. So, for example, the ones that are more labor-intensive, such as voluntary settlement conference, you will not be referred after March 1, and then later in March, the other types, the referrals will stop.
Okay, so what does that mean for everybody? If you want to get into the program, you should do your best to ask your judge for a referral now and try to agree with opposing counsel. I don't mean to, clog the system there. And so in your materials, one of the things you're going to see is that Deborah Rothman wrote an article for the Daily Journal. I think there are a number of people out there who have the perspective that private mediation services and providers are going to pick up these cases that are getting resolved through the ADR programs and I believe they have ADR programs at 13 different courthouses. That's obviously, it's all going away. And so some people definitely feel, hey, no problem, the private mediation's going to pick this up. We'll see how many of those do go into those sort of values of $50,000 and less. That kind of case does go into private mediation. You will find another handout in the materials. It's from the Southern California Mediation Association, and I want to thank their people, Wendy Kramer, Joe Markowitz, and Floyd Siegel in particular, for working with me to get this handout to you. What this organization is going to try to do is fill that gap specifically, and it's well worth your time to take a look at this handout. They're going to try to fill that gap specifically with those cases where there won't be a demand of more than $50,000, perhaps for up to 2 hours worth of a volunteer mediation with their mediators. They'll be randomly assigned. They're in the process of basically preparing that system. And these fine people who are here, you can ask them questions. Can y'all stand up? Wendy, Joe, and Floyd, I'm not sure where you are. Oh, here they are, here. This is a great service. This is a really great service, and they want to hear from all of you about how they can better serve you. They may be sending out a survey eventually. If you see it, respond to it, because they're trying to figure out how to fill a gap for you. So take your time and read that handout. It's well worth it, and then contact them. And in addition, the LA County Bar is going to be, trying to figure out what they can do. If anything here, there's obviously, as Judge Buckley had said, their system is a DOS system, so it's not exactly easy to just hurry up and transfer onto your nearby iPad in terms of the database programs. But the bar is looking at what it can do, and if there's a different or an additional part of the gap that can be filled, and it's possible that eventually, perhaps even starting in 2014, the bar may be able to apply for part of the grant that was given to the court system to subsidize the ADR program, which is called a DERPA grant, whatever the heck that stands for. So not quite, about 90% of cases we know across the country settle whether or not there's an ADR program in the courthouse where that case is filed. Not clear how this is all going to roll out for us and how much longer whether the cases, these sort of smaller value cases are not going to be taken on a contingency basis because it takes too long to get to resolution, all of those things, but we'll figure it out over time. So avail yourselves of the opportunities that are out there.
Thank you, Jeannie. We do have some pretty substantive handout materials that you were all given tonight, and I just wanted to take a moment to point out that we have the Assembly Judiciary Committee report that was prepared by its staff that gives a very detailed macro look at the statewide budget crisis as it is affecting our courts. And we also have a number of handouts that came from CAOC, the Consumer Attorneys Association of California, and they really are at the forefront of lobbying our legislature to make sure that our court has adequate funding. And I wanted to recognize Brian Kabatek, who's here tonight, the president of CAOC. Where are you, Brian? Stand up. He was here somewhere. All right, I have 7:25. At 7:35, we are going to reconvene promptly and have a discussion with all of our panelists, including Judge Buckley, about what this really means. It's going to be your opportunity to ask questions. So grab a drink, have some refreshments, talk to the vendors. We're going to start up promptly in 10 minutes. We're going to go ahead and get started. Gretchen pointed out to me in the materials that if you look at the bios of everyone, every picture is in color except Judge Buckley's. Apparently the Superior Court can't afford color pictures. All right. This is where the rubber's really going to hit the road. This is going to be an opportunity for Jeannie and I to ask some questions of all of the panelists, get the plaintiff and defense perspective and just the litigator perspective, and let Judge Buckley address some of these specific issues. As a reminder, if you have any questions, towards the end we're going to have an audience microphone, but throughout the program, remember, this side of the room, feel free to email me. That side of the room, email Jeannie. It's doug@caala.org or jeannie@caala.org. And take it away, Jeannie.
Go for it, Doug. All right. One of the first questions I have is a good one here. What about the current trial dates?
Do I push as I talk?
What's going to happen with those? Okay.
Is this working out? Thank you. For all intents and purposes, the trial dates in the PI courts will stay the same. We are going to have the judges in the districts analyze whether or not their cases are complicated and decide whether to keep them. But if they decide that it's not complicated and it's going to be transferred to the PI court, up to the day of it being, quote, transferred, it will be handled by the IC judge up to, say, the move date is April 2. Up till March 30th to 31st, that IC judge in Pomona will handle the trial date. If the trial date is March 18th or thereafter, the intent is to keep the trial date there. Then, to get more complicated, if the case is going from, it's remaining in IC court, it's not a PI case. Keep in mind, we're going from 45 IC courts in downtown Moss to 34, and throughout the districts, we're roughly going down from 25 to 50% of the number of IC courts. In those situations, we're letting the receiving judge make a decision whether they want to keep the dates or they want to vacate all dates. So we cannot give you a definitive answer in an individual IC court whether those dates will be maintained.
All right, thank you. Doug?
So let me get our practitioners involved here. Phil, based on the news that you've heard from a defense perspective, what's your reaction to what you've heard tonight?
Well, I don't think I can use that language, but I think they're trying to handle it with the attorneys in mind. I think strategically, from the defense perspective, it's going to be a much more harrowing road. How you tell your clients their exposure when you don't know if the case is going to be in Torrance and downtown is significant. And I think I'm going to believe that there's a lot more complicated cases out there. And my plaintiffs' friends...
Hence why we're not letting the stipulation of attorneys.
But my plaintiff friends are going to have big damage cases. This is a simple case. But I think strategically you're going to be thinking a lot more about venue. You're going to think about it when you get the case, and you're going to think about it and think about this for a second. You go in on your trial date and you see Judge Buckley. He says, you're assigned to Department 47. And you think, okay, well, that's a pretty good judge, but I'm downtown. Maybe I want to use my 170.6 with the hope I get sent out to Van Nuys and Torrance on the next shot. You're going to have to make a very major decision within those 2 minutes of whether you're going to go downtown with the judge you think would be great for this case or whether you want to risk transfer.
All right, Denise, same question. What's your reaction on a macro level to everything you've heard tonight?
Well, I kind of agree with Phil. I was talking to some people outside, plaintiffs' lawyers, who were saying, you know, just the opposite, that they have a case downtown that should be tried downtown, and all of a sudden they get sent out to Pomona or Chatsworth or Pasadena or Torrance, and they're not as happy with their venue. So I think it's going to cut both ways. Can I ask Judge Buckley a question, though?
Sure.
Because I asked him this off the record. He said, ask me in front of the group, because I think the 170.6, which Phil just alluded to, is kind of a dilemma even now as we're in the process of the transfer. I asked Judge Buckley, I said, I got a case out in one of the branch courts, and it's a judge that I'm considering filing a 170.6 on, but it's a med mal and it's a PI case. And so it should be sent downtown. I don't want to waste my 170.6 on someone that may not keep the case anyway. Yet how can I be assured that it's going to get sent downtown? I mean, what if this judge looks at my case and says, oh, I want to keep it? What do I do?
Yeah, we Notre Dame guys say you get the rosary out and then, no. So I think there's a step-by-step analysis. It really starts and ends on whether you think the judge is going to declare or decide that the case is complicated. Because if it's complicated, then you know it's going to be in that district that it is right now. If it's clearly going to be complicated, then you know that that judge that you have right now is going to have the case. If it's clearly not complicated, then you know it's going to pretty much be downtown. So, and if it's in the gray area, and candidly, it's going to be a gray area, a wider gray area, because even the judges have not experienced that decision process yet. So I think that really dictates the decision. It gets more complicated if the case has been so recently filed. When really will that decision be made? And who will make that decision? Because it may well be that the district judges candidly analyze that differently than the 5 judges downtown will. And if it's sort of in the hopper right now, and you need and I tried to, by the way, I did not have quick access to those different courts to the transfer days. I will provide that so that it's out there. So let's create another difficult hypothetical. If your case is in a district that they're not being transferred until mid-May, then it increases the likelihood that this judge you're talking about is going to make the decision. If the transfer of the case is April 2, the first possible date, and it was just filed, then in all probability that judge won't even see it. They'll go downtown, the downtown judge will make the decision, and then it may go back or not. So obviously I can't give you legal advice, but it starts and ends in analyzing how do you think that ultimate decision maker judge will say it is or is not complicated.
Well, but I think as a med-mal defense lawyer, most of my cases, I feel, are complicated. But you have obviously made the judgment that a med-mal PI case isn't complicated.
The input we get from our colleagues, and then actually my personal experience, is that there's definitely a significant percentage of med-mal cases that just don't visit that much. It is, again, complicated case is not that it has a high value. Complicated case is not necessarily that it is going to be a 5-week trial. What it is a complicated case is that how many times are you going to knock on our door and ask for our service? That's really what it comes down to. So it may well be that it's a high-valued case with great lawyers and really tough issues, but there's not going to be a motion for summary judgment because there's no punitive damage claim, and you're not trying to explore which expert is going to opine to what. Not that I've ever seen that happen in a med-mal case. And so there's going to be limited MSJs, and you get along well with your colleague on the other side, and you're not going to really bring us discovery disputes. Hence, that's not complicated to me. And it's tough. It adds to and it could be the next case, you've got a blankety blank on the other side, and you're going to be visiting us all the time. So it is, no pun intended, it is complicated.
So that raises the question, if you have a case that otherwise wouldn't be complicated based on your definition, but the other lawyer, not me of course, but the one filing the case, is very difficult and creates a lot of visits. Is that something that we can tell you when we're trying to get it back to an IC court?
Yes. We will. We are looking even at a way of asking that question as to personal experience. We're not sure how we're going to phrase it, but that is information that, it's a fact of life. Most of us were in your shoes. We know what it is to be day to day and case to case, and we know that your adversary can really change the complexity and the handling of that case.
We're definitely getting the truth here tonight. All right, let's get the plaintiff's perspective. Steve, what's your reaction to all this from a plaintiff's perspective?
You know, I think, first of all, we owe Judge Buckley and Judge Kuhl and the other judicial members here a big thanks. For those of you who don't know Judge Buckley, when he started this about 3 or 4 months ago, he had full dark hair. And, so this has been a full-time project for him. And it could be a lot worse. I was just with some lawyers who were in Ventura yesterday, and they put a moratorium on civil cases there for a couple of weeks because they have to get rid of their criminal calendar. I think what you've seen is that Judge Buckley and the court has done everything that they can to maintain right to access for civil cases. So we really do have that, and we really do thank you for that. So my feeling is that the vast majority of cases are going to work through the system, and it's going to be like what they envisioned, that there's going to be maybe 2 appearances on most cases. You're going to get your final status conference and your trial date, and the rest of the case you're going to have to work amongst yourselves. So how, from a plaintiff standpoint, we either want to get our cases to trial or get our cases resolved, right? So how are you going to do that? It's going to take a little bit of filling out what's going to be the best way to do it. I'm not sure what the best way to do it. My feeling is you prepare every case like it's going to trial, and you prepare it earlier rather than later going to trial, and that's going to help get the defense to realize that you're serious and to get the case to mediation or get it prepared for trial.
Gretchen, your thoughts?
Is this on? Yep. Yes. Okay, I think that there's going to be more people who are trying to find Dustin Hoffman in the Rain Man. Because the one thing that you probably just heard earlier, and you, I hope, picked up on it, was the law of averages and statistics. And so what we now know is there are 10 trial courts in Mosque. There's 1 in Pomona. There's 2 in Pasadena, but remember Pasadena has a UD court. So those UD cases are going to be going to the trial court in Pasadena. There's 1 in Chatsworth, but Chatsworth has a limited or collection case department, right?
Which one again?
Chatsworth.
Chatsworth has a collection court. We don't think that's going to create much demand on the trial court, though.
Right. And then you got 7 in Van Nuys. You got 2 in Long Beach, but Long Beach has a UD court. Torrance has 3, and Santa Monica has 5. So just start doing the numbers when you go downtown. You got to figure statistically your chances are going to be higher that you're going to wind up downtown. That will probably make most of the defense lawyers in the room unhappy. That will probably make most of the plaintiffs' lawyers happy. So I think what you're going to find is people are going to start playing the law of statistics, which is really what this is going to break down to.
So you want to hold your 170.6, so when you get assigned out to Pomona, you can use it then.
All right. Another question, Judge Buckley, are there going to be any changes to the courts and the cases in CCW?
No. We may have, we currently have a plan that however we reduce the court assistant support in a courtroom is currently planned for CCW. So it will not change the cases, the type of cases, the number of courtrooms and so forth in CCW. It remains to be seen how we're going to handle that work given, again, reduced staff.
All right. Thanks.
If someone has already burned their 170.6, does this new system in any way give them another bite at the apple?
I cannot give advice on law. I could see a judge saying you've exercised your peremptory. Okay. And step back again. What we're trying to be very careful with you is to emphasize that the only master calendar department is Department 1 when you're sent out for trial in the PI arena. The IC court stays the same. That is a judge assigned for all purposes. So you have a situation, we have a situation that with 5 judges in 3 PI courts, we're working on a system that lets you know who the judge is on that day when you have a motion being heard, because we recognize that there are deadlines in that situation. But that court is not assigned to you for all purposes. However, that translates into the implementation of 170.6, you have to analyze that. But when you get to Department 1 for the assignment for trial, you are now in a master calendar department, and however you view the implementation of 170.6 in that type of court, you need to understand it's our position. You must exercise the peremptory before you leave the courtroom.
So in light of Judge Buckley's non-legal advice, let me ask our practitioners, what's the strategy now on 170.6? Let's start with Gretchen, go the other way.
Wow, that's a tough question for me. I rarely do them. I kind of figure that, and maybe because the few times I did do it, I went from the frying pan into the fire. So I've sort of taken the position I kind of stick with where I am. And I mean, I think that probably what you're going to see more in this system is the probability that people will be using it, not necessarily for the judicial officer, but more for, I'm not ready for trial yet, or 2, I don't want to be where that jury pool is. I think that's my sense of it, but other people may disagree.
Steve?
May I interject real quick?
Go ahead.
Because I think, again, what I tried to emphasize earlier is critical. I think we're going to take a much more active role in determining that you are, quote, ready or not ready at the FSC and deal with that, you will not, our plan is, you will not go to Department 1 for assignment to trial if in any way you are, quote, not ready. So I understand what you're saying, that you might try and deal with certain situations, but we're going to do ways to make sure that if you're getting to that trial court, you are absolutely ready to start.
I think, looking at the statistics, if you have 31 trial courts, you have 10 downtown and 21 other places, you have a 1 in 3 shot at being downtown, so you want to exercise your peremptory if you're being sent someplace else. So I'm going to save mine until the very end. That's my non-legal advice.
Denise?
I agree with that. I think there is a question, though, if you have a case that you think should be disposed of by a dispositive motion, a motion for summary judgment, and you get, I think it really depends on who's going to be hearing these motions. Because what if it's somebody that, just doesn't grant motions for summary judgment? Maybe you want to use your 170.6 at that point and get somebody else to hear it where you might be more successful. But then you risk losing anyway and then being at the mercy of your trial assignment.
Phil?
You save it. You save it until you're in front of Judge Buckley.
Or whoever else is in Department 1.
That's right.
And Judge Buckley, do you have any more information about the timing and the process that the current IC judges are going to use and implement in regards to deciding whether PI cases that we as practitioners think are complex are going to stay with them or go into the system?
It's difficult. The chicken and egg type thing is that we've wanted to wait until we had the 5 PI judges determined, get them in a room, and really sort of work this out. And when you have a chance to read the criteria for complicated, the definition of complicated, it is difficult to determine. I would throw out that there's going to not be a magic number, but I could see where judges are going to be looking at some kind of a range of possible appearances, and more importantly, what is the complexity of those appearances? Are they going to be one or two? For example, we are looking to have you not only identify how many motions for summary judgment you think you will file, we're thinking of asking you to say what the real dispute is. Is it to determine whether the expert in the med mal is truly qualified, or is it going to be some complicated, esoteric law? So that could say, well, there may not be as many appearances in this case, but the legal issues are going to be extremely complex. It is extremely amorphous. I so stipulate. But I think it's going to be some kind of a gut feel by that judge, and the goal will be that the 5 in PI will be on the same page. And I know that doesn't really answer the question, but that's the best way to describe it.
Judge Buckley, is this going to result in a net reduction of the number of cases that the independent calendar court judges are handling? Because that's had a tremendous effect on the ability to get out for trial and to secure motion dates that are now many, many months in the future. What's the effect going to be on the courts that aren't directly changing as a result of the new PI courts?
It varies district to district. So again, there's no yes or no answer. There are districts such as Pomona and a couple others that have up to 700 to 800 cases per judge. So they're in the extreme of dealing with that problem. But when we take out from that district, and I don't know the exact number for each district, but the districts are roughly between 60 and 85% of their cases are PI cases. And we did is we try to look at that analysis. So there are going to be districts, to answer the question, that they're going to go down to the 400 to 500 range of existing cases. MOSC will probably stay somewhat the same. And the whole calculus of the number of IC courts in each district is based on an analysis that every court will have roughly 45 to 50 filings per month, which we think is somewhat manageable. So over time, we should have an evening of that. But having said those numbers, we're taking out the easy cases. So especially in Mosque, it's 25%. In some districts, it's 80%. So they're going to have less cases, and I think that's great for all of us. But they're not going to have that X number of percent of cases they did under our definition, don't have to worry about as much. So they're going to have a higher percentage of cases that bring a demur to them, a discovery dispute to them. So how that impacts it, we don't know. But the good news is that we are going to get, hopefully, to a 400 to 500 range for all IC courts throughout the county.
All right. And another for Judge Buckley. You mentioned that there are going to be fewer hearings or less hearings. And I think that this may go to motions and that sort of thing. What does that mean? I mean, we know that you're saying with the PI cases that go into the PI system, we're supposed to have fewer hearings, like no CMCs and that sort of thing. But can you elaborate on that just a little bit?
I can. What I'm talking about is a lower number of daily hearings in the individual IC courts. And we have a committee started of judges to look at ways across the board that we can reduce the types of hearings that come to us, ways that we can reduce the paper coming in, et cetera, et cetera. Now, how we achieve this, how we get uniformity, how involved do we get the ultimate leadership of our court involved remains to be seen. And there is a high respect to my colleagues here for judicial independence. But we have only so much that the staff can do. So pick a number. If a judge is averaging 15 appearances a day, of which 4 or 5 are motions, it may well be that that judge will not have more than, pick a number, 12 total hearings, i.e. 12-minute orders, because that's what we're really looking at. That's our new focus, and no more than, let's say, 2 or 3 substantive motions. Don't write those numbers down. I'm not saying that's what's going to be the number. But when I say less hearings, that's what we're focused on. Less average number of minute orders being prepared in that courtroom.
All right, so let me ask our practitioners, if you're dealing with discovery disputes, either you're not getting the documents that you need or you're having to respond to a motion to compel, how is this scarcity of resources going to influence how you deal with those discovery disputes, and do you have any creative suggestions to avoid bringing a motion to court and burdening something that's already being stressed out by all these budget cuts? Let's start with Phil.
I think what we've all been talking about, and this has been a long process with plaintiff and defense speaking with the judges about this, there is going to be a component of an informal meet and confer process likely in the final result.
Yes.
There is, unless it's one of those motions where they won't respond to you, they won't respond to discovery, then that will probably be set for hearing. There's a possibility that there may not be oral argument on some of these.
Possible, yes. We're looking into it.
And so I think the court is leaning on the practitioners to try to resolve it before you file one of those great long questions and answers and dispute Bibles that no one ever reads, except for you. But I think they're leaning on the practitioners to try to resolve it.
We have to have the practitioners resolve far more.
Any other thoughts from our practitioners?
Depending on the case, if you have the right case, you might want to talk to some retired judge and agree and stipulate to have a retired judge get involved. And look, if you're not talking to the other side and you're getting into these disputes, you're never going to agree on having a retired judge. But for example, I have this one case, and we realized that there were going to be a lot of issues that came up at depositions, and we decided that we were just going to have a referee, and we were just going to split the cost and just abide by whatever the referee said. So there would be no motions. We just agreed to do whatever the referee ruled at the deposition. And it's worked out great. I think we all get along anyway, but so it works out good. I don't know how it would work if we didn't get along, but that's one way, I think, to keep things out of the court system.
You know, I think that a lot of the judges, and I've seen this happening already, because quite frankly, I agree with them. I mean, when you get a stack this high of a motion to compel, it's ridiculous. And I see a lot of them offering at either case management conferences or other hearings to say, just put a call into me and let me see if I can give you my informal advice on it off the cuff. You guys can submit a letter or something to the very short that gives me what the details are. It's happening in federal court now. The magistrate judges are doing that more often. I think the judges, certainly down in Mosque, are doing that, and I think you need to take advantage of it. I can't tell you how, when you write the little letter, when you get the lengthy letter back with somebody rattling on about X, Y, and Z, and you say, you know what, let's just call the judge and let's see if he can give us he or she can give us some idea of how they're going to handle it. It has an incredible effect. I mean, so the judge says, I'm going to deny that motion. Who's going to bring it? So take advantage of it.
I would say with confidence that every judge that does an informal conference approach will tell you that the number of discovery motions they get is extremely less in number, and there's few repeat clients, if you will, on that. Take advantage of it. We may make it more mandatory, but please take advantage of it. It goes a long way not only to resolve that dispute, but to avoid future disputes.
I agree with Gretchen and Judge Buckley on that. Judge Buckley, are you going to be encouraging the IC judges who don't offer these informal calls that Gretchen was talking about to do that and be more accessible to the parties?
Define encourage. Yes, I think that's something we'll continue to at least discuss, if not look at ways of encouraging on that. We need that. They need it. The judges need it.
Will that be available on the PI cases with the 5 judges in 3 courtrooms?
Most definitely. The PI judges will definitely provide informal conferences with you. Obviously, the volume may dictate the timing of it. And the only question is what, if any, mandatory requirement will exist?
You know, a couple years ago, the plaintiff and defense bar, together with the court, jointly developed some voluntary efficient litigation stipulations relating to kind of a federal court style early disclosure of various witnesses and documents and other case management techniques, and a short form discovery dispute and short form motions in limine. I haven't seen that being widely used, even though we serve it and recommend it. Has there been any discussion of trying to get a little more impetus behind that?
Yes. I think we've been extremely disappointed in the infrequency of those voluntary efficient litigation stipulations being used, though I recognize that the informal discovery discussions may have replaced that, which is great. But definitely as to the demur attempt, I personally have never seen that, and I don't think any of my colleagues have seen more than a couple. So we do want to look at encouraging it more, and on some aspects, at least in the PI arena, maybe make some of it either mandatory or encourage it in more forceful ways.
All right. Our audience members are asking very good and very specific questions. Judge Buckley, again to you. Will all minors compromise applications in non-pending matters be filed at Mosque? I said specific.
I think that's a probate matter if it's a non-pending case.
Okay.
So if it's a probate case, all probate cases will be downtown.
All right.
So there will be, if in fact it's a case that should go to probate, I don't think our IC judges definitely the IC judges in the districts will not be looking to take it, and all probate cases will be handled downtown.
All right, there it is.
So what's the plan now for MSCs? The court doesn't have an ADR program anymore, or it won't in another month or so. How's that going to impact MSCs? Is there going to be any sort of crash programs for particular subject matter cases as the court has done in the past?
On one of the slides, and I know I went over it, by the sentence I did not actually say it, we are maintaining our settlement courts that are tied, in essence, to the IC courts. So led by Judge Bendix downtown, we currently have 7 bench judges handling settlement conferences, and in various districts we have 1 or 2 handling the settlement conferences. With an asterisk that it takes too long to explain, and it's a moving target. With an asterisk, we intend to maintain the settlement courts, and ideally at the same number. We were looking at one point to increase the number in Mosque by 2, and with them, not necessarily those 2, go to the PI courts. So yes, we will maintain settlement conferences through that program. There's going to, we believe, a higher demand on that because obviously there's going to be no ADR services provided through the ADR department. So we may need to create more rules or standards of what cases the IC judges send to the settlement courts.
And for our practitioners, is your approach to alternative dispute resolution going to be any different now that the court no longer has its own ADR program?
Well, what motivates settlement? What motivates people going to ADR? A firm, sure trial date, right? And so, let me ask Judge Buckley. I mean, with the system that you have now, is your 18-month trial date going to be a firm trial date? With your crystal ball.
I love the look on Judge Buckley's face right now.
All I can do is give you certain numbers. We're going to have 16,000 cases filed each year, less roughly 20, we think 25% because they'll be deemed complicated. I hope so. We're going to work so hard to have firm trial dates. We may realize that 18 months is not feasible. We may realize that we may have to get very aggressive on the ADR between the FSC and the trial date. But day one of judge school, they tell us what you know as a lawyer. A firm trial date is the best way to settle a case. So we know that, and we're going to do our best to try and do it. And we're going to try and do all these cases coming from the districts. Judge Kuhl and I have sat down and looked and said, we really have to have these trial courts up and running and ready to go because we want to give you firm trial dates over the next 6 months. It'll be challenging.
All right. Judge Buckley, can you explain how trials are going to be assigned through the PI system?
I'm sorry, repeat it,
Can
please.
you explain, please, how the trials are going to be assigned? You mentioned that it was going to be based on availability, but can you elaborate on that?
Well, what I mean by that is that you're going to walk in to Department 1, and you're going to be walking in the door at the same time. A couple people from the UD court before Commissioner Harrison are going to be walking in. They're going to have a statutory priority over your PI case, and we might have a couple cases coming in from limited. So I don't know how we're going to give a priority yet. Do we give a priority to the oldest case? Do we give a priority to the case that fits into the time availability of a judge? Do we look at candidly a random system so that if we can't get you all out to trial, you're thinking you're going to go out to trial and you can't really look and compare filing dates and therefore you've got to be ready, i.e. start really being serious about settlement discussions? I think we're going to have to get into the trenches to really give you an answer on that. But having given you all the options, I think it's going to be somewhat random in that we don't just go directly down the age of the case for that settlement pressure that I think you want us to give you.
David Hoffman over here has a microphone. If anyone has a question, just kind of flag them down and you can ask your question of the panel.
Thank you. This question is for Judge Buckley. Thank you, everybody, by the way. For those of us who have trial dates that are set currently within the next 30 to 60 days in the courthouses that are closing. When should we expect those courthouses to be closing, such as Beverly Hills?
The closing of the courthouse really has no impact on a civil case trial date or other dates, because we're transferring those files somewhat independent of the closing. I think Beverly Hills may be, I'd have to go back and look, I think Beverly Hills might be the only courthouse closing that has general jurisdiction cases, because I think the rest have civil cases, but they're limited and or the especially small claims and so forth. So all you're going to look at is the Santa Monica date, because Beverly Hills is tied to Santa Monica. Whatever that date is, of the cases being transferred from Santa Monica to the PI courts, is going to be the date that's going to dictate whether your trial is in Beverly Hills or in the PI, going out of the PI court, putting aside the complicated decision. Does that answer your question?
Well, so Santa Monica is closing a lot later, or Santa Monica PI cases are being transferred, I think I recall, a lot later than some of the others.
Right. Beverly Hills will definitely, the courthouse will close after all these cases are transferred.
So it's probably not before the Santa Monica PI cases get transferred downtown, is that?
Right. So Beverly Hills cases will be transferred on the same date as Santa Monica cases. All cases being transferred in the civil arena will happen before any courthouse is closed. So if you're worried about a limited case, that case will be transferred downtown. A non-collection limited case will be transferred downtown, again, before any courthouse is closed. The courthouses are going to be closed much later, later on in the process. General jurisdiction and limited jurisdiction.
Did we have another question over there?
Yes, I'm Stuart Rice. I sit as a judge, civil court in Torrance, and I couldn't resist the opportunity with all these really high-powered, skilled attorneys. We have started a crash settlement program in Torrance so that we're going to send fewer, hopefully, PI cases downtown when our day comes. It is March 25th through the 29th. We're going to do 40 a day, 200 for the week. And if anybody's interested in serving as a settlement officer, I'm over here. Just hand me your card, and we'll be in touch with you once we set it up. Thank you.
Thanks, Judge Rice.
Can I ask, a question for Dan. Dan, on cases that are going to get transferred on whatever date they're being transferred out of the districts, if we already have a final status conference date set, will that date still be a good date for appearing in the PI court downtown for the final status conference?
The plan right now is to keep the FSC date as scheduled, and therefore the judge in the district, using that example, would handle the FSC. What we're going to do is ask the judges that customarily rule on motions in limine at the FSC is not to do that, so that the trial judge decides the motions in limine. But a reason why we're doing this, a significant reason why we're doing this, is that our technology system cannot take some dates staying and some dates going. So we have to keep all dates on the system, and that's really the driving force as to why the FSC date we're going to keep, albeit a different judge than the trial judge, but we're going to look to that district judge to make sure the case is, quote, ready.
When I file a new PI claim now, PI complaint, will I have any input on the date of trial?
I'm sorry, I didn't hear the last part.
Will the attorney have any input on the date of trial actually given?
No. Right now, here again is the process. Right now, we believe 18 months might be an optimum time for the trial date. So that filing clerk downtown will have a little chart as to what's the 180-day, the 18-month date and the FSC date that goes with it, and the 3-year plus 1 day date. That will be given to you in an order. We met with the lawyers. Most lawyers thought that 6 months should be enough time for a typical PI case to effectuate service. So with that, the date you're getting at the 18 months is assuming, or really conditioned on, that you complete service of the defendants in 6 months. If you do not complete it in 6 months, that trial date is no longer a date that you can use, that we're not going to contact you on that. So one of 3 or 4 things have to happen. You may show up on the trial date, and if the defendant raises the objection that the service did not occur in 6 months, then the date of trial will be continued. I'm sorry, I didn't hear that, so I'll have to come back to that in a second. Second of all, what you could do is get a stipulation from the defendant. You know, we've had enough time, we'll stipulate to keep the 18-month date. But I think this addresses your concern. In the PI cases, I think we're committed now to have a stip and order accepted as to any continuance of any trial date. And so if you file with your filing fee, because we want to make sure we have our filing fee, a stip and order that the trial date is continued a year later. And I think this is sad. I think this is very sad. We are not going to care. And that trial date can be moved by that stipulation. It's sad because we're losing the ability to get you quick trial dates. But that's how, if that date of 18 months is inconvenient, get a stipulation, we will accept it.
Mary Ann?
Judge Buckley, first of all, I want to say thank you. I've seen you before, and this must take a toll on you doing this all the time, and you're doing a great job.
Well, you heard I didn't have any gray hair.
So thank you. I can't imagine anyone else that would deliver this news with such good passion, so thank you. But I have a question. Okay, so I'm going to follow up on what you just said. If we don't file in 6 months, we lose...
You don't serve in 6 months.
If we don't serve in 6 months, do we lose the 18-month trial date and we're at the 3-year date? Or what happens?
Well, hopefully you'll confer, you're communicating well with your adversary, you work out a date, you file a stipulation, and to either keep that date or have another date later on that gives everyone enough time. But otherwise, you'll show up on the trial date, and if there's an objection by the defendant that the service did not meet that 6-month deadline, then we're not honoring that trial date anymore, in fairness to the defendant, and that PI judge will give you a new trial date. How far out, I don't know. Does that answer the question?
Judge, where are UM and UIM cases going to be filed?
UM cases, I believe, fit the definition of a PI case. And I believe if you go to that addendum that I identified, it's specifically listed. So it will be a PI case filed downtown in the PI courts.
And will the judge pro tem program still be in effect, or is that being terminated?
It is definitely not, it's not being terminated. It is something I think we're going to continue to look at. It is staff-driven, and anything that's staff-driven is subject to reduction, maybe termination. We are looking at 2 bench officers for each small claims court, not traffic court, which I'm identifying courts that would require the pro tems. So I think our need for pro tems will go down as well, but there is no decision yet as to any formal reduction, or definitely no decision on termination yet.
I think we had an audience question. And just a few more questions, folks, because we're going to have to wrap this up.
Marvin Lanter. I have a question. Okay, I have a very unhappy witness I have to subpoena to trial from Pomona. This unhappy witness then is going to have to come downtown to be told that day that they're going to have to go to Chatsworth the next day? Is that theoretically what could happen?
It's, I think, unfortunately beyond theoretical. I mean, that could well happen and will happen. This is definitely something we discussed with the group. For what it's worth, in the almost 3 years that I was in Mosque doing civil after I came from actually Pomona, coincidentally, I never had a witness show up in my courtroom for a trial date. And that was I think the collective experiences of the lawyers that situation you described is very rare, but there's no way around it when it does happen. It will happen, I agree with you. It may underscore the effort to get a letter to show up and so forth, but that is one of several very difficult situations for you. Well,
Marvin, you're a charming guy. I can't imagine a witness not like it. But what he's saying is we've struggled with that issue. And it's certainly more of a burden on the plaintiffs because they've got to be ready. And so we have been trying to figure out some way around it. And any ideas we'd look at. But it's an issue. We understand it. And it's a concern when you have to say, hey, thanks for coming. Here's another subpoena. I'll see you tomorrow.
well, if you get them in the courtroom, I can order that person to go somewhere on a certain date. And I'm going to try and say this in the right way because I think your question is extremely valid. What am I going to do to help you? I recognize that is an extremely valid question. But I smiled because our opportunity to help you is going dramatically down. And when I joined the court in 2002, led by Judge Basque at the time, we proudly said that we were the Nordstrom of the courts. We were the best neighborhood court in the world. And we took pride in that. We're no longer able to provide Nordstrom service. And again, I'm not trying to be flippant because you're right. I would love to work with you and give you assistance in that. Our ability to assist you is dramatically reduced, and we're so sad about it.
So as a follow-up question to that, let me ask the attorneys, how do you most effectively use your subpoenas for witnesses at trial and on-call agreements, given the fact that you don't know exactly where you may have the case tried?
I mean, I think you have to get people to sign an on-call agreement and tell them if you don't, here's what's going to happen. And I think most people will do an on-call agreement. Of course, you've got problems when you got police officers because they won't agree to an on-call. And so those are probably the ones, Judge, that you're probably going to have to order to appear someplace, probably police officers.
Question. You said when you file the complaint, you get 3 dates, and I was a little bit confused because we were talking about different dates. What 3 dates are we given when we file the complaint?
You will be giving in order of, or in chronological order, an FSC date, a trial date, and a 3-year plus 1 day date. And
you might explain that. I think most people
okay.
don't remember what the 3-year or 1 day means.
Right, and again, that's the good news is that we have gone so long now that people don't appreciate that there is maybe a discretionary 2-year statute for failure to prosecute, but there is a 3-year statute for failure to prosecute. And if there is that failure to prosecute at 3 years, the case can well be dismissed. So what we want is to avoid staff time trying to send out notices of trying to get people back in to try and decide whether the case will be dismissed. Or we're trying to set up a date so that if we don't hear from you, we don't have to try and find you. We can simply, on that 3-year date plus 1, dismiss the action.
Judge Buckley, I was just wondering if you could shed some light on what will happen to existing motion hearing dates that have been set, for example, motions for summary judgment that are set for after the file transfer dates.
We're keeping all dates. Well, again, I have to step back. There's different answers depending whether it's a PI case or an IC case. So if it's going to the PI court, the date and the time will stay. We do plan, as an aside, to have staggering times of hearings in the PI courts just so that the different judges can be on the bench at different times. But so if it's a PI case, all dates will remain the same, including hearing dates. The IC case is going from one IC court, but because that IC judge is no longer going to handle IC cases and it's going to a lesser number of existing IC courts, we don't have a definitive answer. Right now in Mosque, we have a difference of opinion of judges as to whether they want all the dates vacated or all the dates kept. It has to be all or nothing. And we're going to try and accommodate that. Let that receiving judge get his or her preference. We're going to probably, as long as technology will allow it, we're going to provide that same option to the districts. So it's going to be totally dependent on your receiving judge desire.
All right, okay, to the practitioners, something we really want to hear. Can y'all give us the skinny from the plaintiff and defense perspective on how you really think these changes and delays are going to impact your caseload, your cases, you know, all just trying to encapsulate it, but give us the whole skinny. Gretchen, why don't you start?
How's it going to impact the number of your cases? I have to tell you, those people, my perception of this is those that do cases that are perhaps on the financial level a little bit lower may find that they are going to be wanting to increase their caseload because there's going to be, I think, a lengthier period of time until a case gets resolved. And so if you're trying to juggle financial issues, you're going to have to recognize as a business that you're going to have to have a little bit more economy of scale and get more cases in. That's just my off the cuff. For many practitioners that do cases that are what I would call on the financial end a little larger, I think probably this is going to continue on kind of business as usual. I think there's going to be some differences, obviously, in terms of issues on how you evaluate the case, knowing that there is this unknown factor of where you will ultimately try it. But I think as time goes on, those issues will probably work their way through, and I think you'll probably get a better sense of that as time goes on. I would remind everyone in this room, something that probably people don't want to hear. This is not because the LA Superior Court just wants to do it. This is because there is a severe budget crisis in California. Prop 30 did not alleviate that problem. So another way you can help is pay more taxes.
That means make more income, so that's good. So I think that, looking back, when I started practicing, it took 5 years to get a case to trial. And we'll survive that. I think that lawyers, you tell us what the rules are, we're going to figure out a way to survive, we're going to figure out a way to adapt. My sense is, as things work through the system over the next year or two, it's probably going to slow down a little bit. And you have to have, like what Gretchen said, you have to have cases in the pipeline so that as a case finally works its way out, then you have another one behind it. And I think that's going to take probably a year or two for people to really adjust their practices. But I think after that, it'll be like it was back in the old days. It takes a while to get to trial, but you have enough cases moving through the system that you're okay.
Yeah, for those of you who don't remember, some of us actually did process through the beeper, through to what everyone said, oh my God, egads, we're going to IC, that's never going to work. I mean, it was, the sky is falling when we went to IC. So then we got to IC and it worked out pretty great and everybody was like, wow, this is pretty cool. And now we're kind of going back to a little bit of a blend. And I think Steve's comment is right. We are all adaptable. That's the nature of the beast.
And Denise?
I think it's going to take a few more months to figure out how it's really going to work. I have a burning desire to know who our trial judges are going to be. And we're going to know that soon, right?
Yes.
And I think, who are our trial judges? Are they really going to be able to keep our FSC and trial dates? There's so many questions that are unanswered now. How are we even going to find out where our cases are going to be transferred in the next couple of weeks and months? I agree with Steve that I also carried a beeper for a few years, and we all survived it. But the cost of litigation is so much higher now than it was in the 1980s. Our expert fees are wildly higher than they used to be. And I think if we get to the point where we're continuing trials 5 years, it's going to have a huge effect. Maybe more on the plaintiff than the defense, but our clients on the defense side are not happy as it is with the way cases are getting continued. So it's going to be a problem, I think.
All right, and Phil, what do you have to add? How does this change your practice from a defense perspective?
I agree. I think it's time to go to the bar.
You told me that 2 hours ago.
I think, though, as we are working through all this, I think one thing to keep in the back of your mind is that it could really be a lot worse. And so just kind of keep that in your mind as we're working through it.
A question was asked as to whether or not a copy of my PowerPoint can be available, and the answer is definitely. There's nothing there that is a secret. So I will look to Doug or anyone else to provide the opportunity to access it, or I'll give it to Doug, and then Doug can work out through both groups as to how you can get it. Let me emphasize that for whatever bar group you're working under, we are here to meet with you. So I'm happy anytime to meet with a small group, a large group. I've met with even law firms and so forth. Judge Wesley and Judge Kuhl are giving up much of their time to meet with lawyers and bar groups and so forth. I'm not volunteering necessarily additional time on their part, but we will be there to answer any questions. And when we do know the assignments, as we refer to it, we will provide that as quickly and as detailed as we can. Obviously, that can change a little bit here and there, but we'll provide that. Again, this is something, as Gretchen said, it's the last thing we want to do. But we're know full well that the best way it's going to succeed is that we work with you and we communicate with you, and we will be an ongoing effort.
I can't thank everyone up here enough for all their efforts. Please join me. Thank you all for coming, and have a great evening.